Someone lies about you at a party, destroying your reputation. You want to sue for slander, but the court says prove you lost money. Meanwhile, the same person writes the identical lie on Facebook, and suddenly you don't need to prove damages anymore. Welcome to slander law, where spoken lies get special protection. Slander is defamation in spoken form. Temporary verbal statements that are not recorded. But unlike written defamation, slander makes you jump through extra hoops to recover damages. Courts assume spoken words are less harmful than written ones. And the basic rule is you must prove special damages. That means showing specific financial losses caused by the false statements: lost job, lost customers, lost business opportunities. Courts want receipts on how the lies cost you money. This creates impossible situations. Someone spreads lies about you at work, everyone treats you differently. Your career stagnates, but you can't prove the connection. Without measurable financial harm, you lose, even though your reputation's destroyed. But there's an escape hatch: slander per se. 4 categories of spoken lies are considered so inherently damaging that courts presume harm without requiring proof of financial losses. Category 1, improper professional conduct. Falsely accuse a doctor of malpractice, a lawyer of being incompetent, or a teacher of inappropriate behavior, and you've committed slander per se. Professional reputation is considered so valuable that lies about it automatically create liability. This covers any false statement that attacks someone's professional skills, ethics, or fitness for their job. Say a surgeon operates while drunk, an accountant embezzles money, or a contractor uses shoddy materials. If it's false, it's slander per se. Category 2, criminal accusations. Falsely accuse someone of any crime and you've committed slander per se. Doesn't matter if it's murder or shoplifting. Criminal accusations are presumed to cause automatic harm to reputation. Now, this creates huge liability for casual accusations. Call someone a thief, a drug dealer, or a rapist without proof, and you're facing slander per se liability. Even minor criminal accusations like she steals office supplies can trigger this rule. Category 3, loathsome disease. This category comes from historical fears about contagious or stigmatized diseases. Originally focused on leprosy and venereal diseases, modern courts have applied it to HIV, mental illness, or other conditions that create social stigma. Falsely claim someone has HIV, is mentally unstable, or suffers from addiction, and you might face slander per se liability. The idea is that disease accusations create immediate social isolation and harm. Category 4, unchaste women. This is the most outdated category, originally meaning accusations that an unmarried woman wasn't a virgin. Modern courts struggle with this category because sexual morality standards have completely changed. Some courts have updated this to cover false accusations about anyone's sexual behavior that would harm their reputation in their community. Others have abandoned it entirely as reflecting outdated moral standards. The problem with slander per se is that these categories were created centuries ago when society had very different values. Accusations that were socially devastating in 1800 might be meaningless today. Workplace slander is where most cases happen today. Office gossip about someone's professional competence, false rumors about criminal behavior, or lies about personal conduct that affect job performance. The bottom line, if you're going to lie about someone, the law prefers you do it verbally rather than in writing. Spoken lies get legal protection that written ones don't, even when they cause identical harm. So remember, slander law makes it harder to sue for spoken lies, but the 4 slander per se categories can still create massive liability for the wrong verbal accusations.